Hello everyone, this is Arindam. I welcome you all to yet another session from Khurana Khurana in association with IIPRD Consulting. Today's session will be talking mostly about trade secrets, what comprises them and how to manage them in the current situation, in the current business environment and all. I have with me Mr. Donal O'Connell. He's a UK-based consultant. Donal, can you maybe introduce yourself?
Thanks, Arindam. Yes, I'm based in the UK, so good afternoon to all of you there in India. I'm not an attorney, although I spent a lot of my time as director of IP at Nokia, the phone company, for many years, and I run an IP company here in the UK for the last 9 years, and heavily involved in trade secrets. So, looking forward to today's webinar.
Yeah, sure. Same here. We look forward to having a great discussion here. So this is almost 2 p.m. I think we can set the ball rolling. We can start our session. So Donal, I think most of us here who are present in this session, they may know a little bit about trade secret, because some of them are lawyers, some of them are budding lawyers, some of them are having some kind of businesses of their own, researchers. But in your words, how would you define trade secret? What comprises trade secrets?
Well, there are subtle differences in the laws from one country to another, but in general, it is business information that is secret, has value, and where you've taken reasonable steps to protect it. So it's quite broad. There's no requirement, for example, for it to be technical. Some trade secrets can be technical, but some are maybe financial information or client lists and so forth. It's not a registered form of IP. There's no requirement to go to the Patent and Trademark Office like you do with a patent or a trademark. It is, as long as you can keep those three requirements, that it is secret, has value, and you're taking reasonable steps, then it is a trade secret. So it's a rather unique form of IP.
Okay. And then if we want to know like the growing importance of trade secret in the current context, so a lot of people talk about IP per se, but trade secret, it kind of felt like it's like a Pluto in the IP world.
Yes.
Sometimes it's there, sometimes it's not there. So how do you see the importance of trade secrets?
I agree. Up until a few years ago, it was probably the neglected stepchild of IP. A lot of people ignored it. It was rarely covered in IP conferences, rarely talked about. In fact, many in-house IP managers probably didn't even see it as part of their job spec. However, it has been changing. That situation has been changing, and it is clearly growing in importance for a number of reasons. The primary reason is perhaps the fact that trade secret laws have changed dramatically in key jurisdictions in the last 3 or 4 years. Japan in January 2016 updated their trade secret law. They had made some minor changes in previous years, but they made a major change in January of 2016. Then the US brought out federal trade secret law in May 2016, the Defend Trade Secrets Act. Then Europe brought out the European Directive on Trade Secrets in June 2016, giving member states 2 years to enact that legislation, and most countries did it by June 2018. And China, although it has a group of rules and regulations, the primary trade secret law is their anti-unfair competition law. That went through changes in 2018 and 2019. So in the space of 3 or 4 years, we've seen dramatic changes in the law. And the main changes have meant that the pendulum has swung. It's much more now favoring the plaintiff, the trade secret owner. There's a better definition. But also, if you go to court, it is possible now to keep your secret before, during, and after the court case. And of course, the penalties for trade secret theft have increased. So you now have heavy fines and people in prison for trade secret theft. So that's been one major change. However, I would say that there are other changes as well. Clearly, there's been more trade secret disputes. primarily in the US, but not just in the US. And even in the US, not always involving US companies. In fact, European, India, and Chinese companies have all found themselves in court in the US facing trade secret issues. So litigation is increasing. At the same time that trade secrets have been increasing, I would argue that patents have somewhat weakened a little bit, in the sense that primarily in the US with patent reform, it's somewhat more challenging to get a patent. It's more difficult to maintain a patent, and it's more difficult to enforce a patent. So at the same time as you've had trade secrets increasing in strength, an alternative form of IP, namely patents, has been through some would argue subtle, some would argue a little more dramatic changes, weakening that form of IP. And then I would like to highlight one other change. I think technology is changing. More and more of the world is software. More and more of the world is on the cloud. A lot of the technologies these days are algorithms and data. And in those type of technologies, protection is more, trade secrets is probably a more suitable form of protection rather than patents. Because if your algorithm is hidden away in the cloud, why patent it and divulge it when you can just keep it secret? So I think that there's a number of changes taking place, all meaning that trade secrets have grown in importance. There are others as well I can go into, but I think they're probably the main ones.
Okay. And if we talk about companies per se, what would be the best practices that companies can follow to enforce trade secrets in particular?
Well, I'm going to answer that by starting about bad practice. Unfortunately, most companies are not taking trade secrets seriously. I know that from my own experiences working with lots of companies over the last few years, but also there have been reports and benchmarking studies that say the same thing. There have been surveys in Europe of some SMEs. There have also been global surveys and so forth. And many companies are poor, unfortunately. First of all, there's a lack of awareness and understanding within organizations. People confuse, they have a misunderstanding about trade secrets. They confuse them with similar but not identical issues like confidential information, know-how, and even patents. A lot of companies lack a robust trade secret policy. They have no process to identify trade secrets, to track them. Many companies, they can tell you how many patents they have.
Yes.
They can tell you how many trademarks they have. But then ask them, how many trade secrets do you have? Well, the answer is often, I don't know, which is not a great answer. Oftentimes they do not track which trade secrets have gone out the door, being shared with collaboration partners, suppliers, or the reverse. They don't track which trade secrets have flown into the organization. Trade secrets often aren't communicated to the key senior managers. When the IP department presents to senior management, they're more comfortable speaking about patents and trademarks and registered forms of IP. But many do not communicate about what's going on with trade secrets to senior management. So there's a lack of communication there. I also think there's a lack of governance. And by that I mean metrics, budget, decision-making, and so forth. So unfortunately, for many companies, the situation isn't about best practice. Unfortunately, the situation is things aren't very good. Now, that said, there are companies who are better, who are taking the situation seriously. They tend to have a number of things in place. First of all, if you look at how they're educating their employees, there is a trade secret component. Yes, they may educate them about patents and trademarks, but they also educate them about trade secrets. And education is crucial. It's fundamental. If the people don't even understand trade secrets, well, then how can they look after them and so forth?
Yeah.
They have a good trade secret policy, a robust policy that explains the overarching approach of the company to this form of IP, but also that policy then perhaps impacts other policies or related policies like HR policies, security policies, IT policies, publication policies, and so forth. Thirdly, they have a process. Just like we have a process with patents, how you get from an inventive idea through drafting, filing, prosecuting to get to a granted patent. The same applies to trade secrets. There's also a process. How do you identify the information? How do you analyze to determine whether trade secrets is the best way forward? How do you make a decision to keep it secret? How do you then protect it? And how do you make sure going on that you keep that protection? So there's a process. They often have systems because once you have more than a handful of trade secrets, you need some sort of system to underpin that process. They track metadata about their trade secrets. They have good contracts, or they have good trade secret provisions in contracts with others. And last but not least, they have good governance. So there are best practices out there, but I must admit, unfortunately, that many companies are poor, or many companies are just starting their journey, trying to figure out what they need to do to get good and improve their situation with trade secrets.
You talked about the companies doing about themselves. I just wanted to understand, how should an MNC company, someone who has international branches or operations in number of territories or jurisdiction, how should a company like that manage their trade secret? Because something would be in their headquarters or site of origin, something else in other branches and all.
Well, I personally believe that the legal IP function within the company, first of all, needs to take ownership. There needs to be some central corporate function that feels ownership for trade secrets and starts putting the various policies and processes in place. Obviously, that function will have to reach out to various group members around the globe and then influence those different group members to take the issue seriously and start taking the appropriate steps. Often, if you're starting on this journey, it's good to do an initial pilot. Maybe the corporate legal and IP function should initially pick one particular part of the organization, maybe one R&D function, one factory or whatever, and use that as a test bed to, put a policy in place there, put some training, put some processes, identify the trade secrets within that particular part of the organization, understand how agreements are being used by that particular corporate group or whatever, put some governance in place and learn from that pilot. And then once you've got it working well there, roll that out to the rest of the organization. Obviously, if it's a corporate M&E with activities in different jurisdictions, it clearly needs to be aware of the trade secret laws in each of the jurisdictions in which it operates. But not just in which it operates, but in which its ecosystem operates. Because you can, for example, be a company in the UK and suddenly find yourself impacted by US trade secret laws. Or you can be a company in the UK and be impacted by Chinese trade secret laws. Or you could be a company in India impacted by trade secret laws in other jurisdictions because you have some involvement with that jurisdiction. Either you have suppliers coming from there, you have investors coming from there, your products are on sale there, and so forth. So one needs to not just look at the profile of the company itself. You clearly need to understand what's happening with trade secret laws in the key jurisdictions, because there are lots of examples of companies being impacted by laws in jurisdictions and where they're actually not based. Mm-hmm. But my strong suggestion would be that the legal IP function takes ownership, that they do initial pilot, particularly if they're a large company. You don't want to do a sort of big bang approach. It's best to test it, first of all, in one particular part of the organization. And then once you learn from the experiences there, deploy it to the rest of the organization. The same way as you handle other aspects of IP, the way you handle patents, trademarks, because again, with those forms of IP, things will happen in different parts of the organization. Inventors can be in different locations. Your patents can be in different jurisdictions, etc., etc.
So if we talk about a little bit on the other side of trade secret, what would be some of the risks associated with trade secrets? Can someone say that this is risk and all?
Well, unfortunately, trade secrets are fragile in the sense that once the information becomes public, you can't sort of reverse the situation and then make it go back being a secret. It's too late.
Yeah.
So you've got to understand that it's a fragile form of IP. You have to keep it secret. But if it's unwittingly or deliberately disclosed, it's gone. So in a sense, you've got to have a little bit of paranoia to say, well, I've got to assume the worst and I've got to be paranoid about these assets. Remember, trade secrets can be among the most valuable assets in the company. If you think about it, things like, Google's search algorithm, Facebook's data set, the Coca-Cola formula. Some of these trade secrets are gold. They're nuggets. These things have to be looked after. So the risks are within companies. First of all, is that there's a lack of appreciation. The companies aren't even aware that they possess these valuable assets. So that's one risk, the fact that you don't even know what you have. The second risk is that you don't take the appropriate steps. It's very easy to say, let's keep something secret. It's much more difficult to actually keep it secret. And that's the challenge for companies. You actually have to do something. You have to keep it secret. And by that, I mean you have to wrap the secret in layers of protection. Some administrative protection, some legal protection, and some technical protection. Administrative protection would be things like educating the people who've got access that this is a really valuable asset. Legal protection will be things like agreements, confidentiality provisions, and so forth. Technical protection will be things like encryption, access controls, and of course that will depend on whether we're talking about a paper trade secret or electronic trade secret. But you've got to protect it. Another risk is the fact that companies are embracing open innovation. Now, open innovation is where you collaborate with people outside your company. And open innovation, there's nothing wrong with it. It's clearly a new way of thinking about innovation. So companies are more and more collaborating with key suppliers, universities, communities, and so forth. But you've got to realize that when you collaborate with somebody else, more than likely you're sharing trade secrets with them. Because in order to collaborate, I've got to tell you things. I've got to tell you about my plans. I've got to share with you my software code. I've got to share with you my data. I've got to share with you my financial information and so forth. It's almost impossible to do collaborative innovation or open innovation without sharing trade secrets. Now, unfortunately, some people assume that just because the other party signed the NDA, that everything is okay. But NDAs are like confetti. Lots of people will sign them. What you need to ask yourself is the other party actually capable of looking after my secret? Just because they signed an NDA, I'm more interested in knowing what's their trade secret policy? How do they protect trade secrets? Are they actually capable of looking after the trade secret I'm going to give them? Because if you look at lots of the disputes that take place, lots of them are between former collaboration partners that have fallen out. So this risk to do with collaboration needs to be understood, and it needs to be understood. Another risk is your own employees. Now, I know people say that your employees are your most valuable asset, and that is true. You should respect your people, you should look after them, and you should care for them. But there's been a change in the way people and the way the relationship between employees and employers. A long time ago, people would join a company and stay there until they retired. Those days are gone. People move around. People move around a lot more these days. So the loyalty between companies and their employees is different. Now, unfortunately, some people on their last day of employment do the following. They plug a memory stick into their computer and they download a whole lot of files, or they upload a whole lot of files up to Dropbox, or they send a lot of emails to their home email address. Now, I suspect that those files aren't things like what's on the company canteen menu. What's in those files are things like customer lists, software code, process descriptions, data. So unfortunately, some employees steal your trade secrets.
Okay.
So there are lots of risks to go with trade secrets. And they need to be understood and they need to be mitigated if you're going to be successful.
Okay. But just to wrap things around this, so let's suppose if there's a company and they are acquiring another company which owns IP along with some trade secrets and all. So if you have kind of like a checklist or what kind of things they should consider, some top level things like due diligence and all, during due diligence,
Yeah.
what are the things they should look at?
Well, unfortunately, in many IP due diligence exercises associated, for example, with M&A activities, oftentimes the IP due diligence exercise is done quite late in the process. There's a lot of time pressure on the people conducting the IP due diligence. And when I look at a number of IP due diligence exercises, it's often easier for the IP person to focus on the easy to obtain information about the target company. So you often see a strong focus on things like patents and trademarks and so forth. And the unregistered forms of IP get ignored. Oftentimes, trade secrets aren't even discussed. The second challenge is, even if they are to be discussed, there's this fear that, well, how do I ask about trade secrets? What questions do I ask? Because the target company will say, probably, I'm not going to tell you my trade secrets. And rightly so, because the deal may not progress and they may be very reluctant to divulge their trade secrets to a third party with the possibility that the deal does not go through. However, trade secrets are the most valuable assets the target company may possess. So ignoring them is probably not the right answer. The question is, how do you go about it? I suggest that this is where the use of trade secret metadata can be very valuable. So you can ask about the trade secrets without actually asking about the trade secret itself. So for example, you can ask, first of all, you can ask about the target company's approach to trade secrets. Do they have a policy? Do they have a trade secret process? Do they log and classify their trade secrets? Do they have trade secrets shared with others? Are they in possession of trade secrets belonging to third parties? Do they have a governance of trade secrets? Do they report on trade secrets to management? So you can ask management type questions to get you an understanding of, have they got a serious approach to trade secrets? Then you can ask questions about their portfolio of trade secrets without asking about the actual secret sauce. You can ask, for example, things like, well, do they classify their trade secrets into different categories? Do they have technical trade secrets, financial trade secrets, marketing trade secrets, raw data, software code? How do they protect these trade secrets? Do they have a combination of legal and technical and so forth? What type of metrics do they have regarding trade secrets? So in exercises I've been involved, we've been heavily using metadata because we accept that unlike a patent or a trademark, it is challenging to ask the other party, say, tell me your exact trade secret. That won't happen. But that's not an excuse to completely ignore trade secrets. You need to get, if you're involved in an M&A and you're on the buy side, you should at least understand something about the trade secret assets of the target company you're about to acquire, or you're acting on behalf of a buyer. Now, There's another issue you need to think about when it comes to this issue, in that the tax authorities are also getting more and more interested in intangible assets, particularly when it comes to multinationals and having complex group structures and intergroup licenses and so forth. The OECD BEPS requirements that came out a couple of years ago basically are guidelines from the finance and tax community telling companies how to behave themselves when it comes to the management of IP assets, particularly if those assets are moving around between group members. And the OECD BEPS, interestingly, includes trade secrets as a form of IP that needs to be managed by multinationals. And it gives clear guidance about how they expect you to manage those assets. They expect you to know which group member in the company owns the trade secret, which other group members have contributed to that trade secret in either the development of it, the protection, the enforcement, and so forth, and have those group members being compensated appropriately at arm's length arrangements? And are you reporting these assets to the various tax authorities in your annual reports or country reports and so forth? So there's another issue you need to also think about when it comes to trade secrets, that it's not just the law, there's also financial rules and regulations beginning to come into this space.
I think overall that would be a lot of things to consider. It would be a long list on itself in a way.
Yes, it is a long list, but I think the days of just saying, well, we can ignore trade secrets are over. That's not an option. And for companies, you have to start slowly on this journey. Now, for lots of big companies, this journey will take some time. They're not going to magically transform themselves into being world-class at trade secrets in a day, but they need to start this journey. And we know that many companies are starting this journey.
So before I take this discussion forward, I would just like to know from my audience here, participants here, do they have any questions so far on the discussion?
Hi, Arindam. I have a question.
Yeah, Hasinda, please.
Yeah. Hello, sir. My question is, what are the bases on which one can decide whether a particular invention, for example, they need to protect as a trade secret or rather as a patent? What are the basic priorities which are set before deciding by any company which one should they opt for?
Yeah, I mean, it's a good question, because obviously one place that trade secrets can be formed is during the invention handling process, when you're deciding, do I take this invention on for patenting or do I keep it secret? Obviously, when you're deciding whether to patent an invention, you ask yourself a variety of questions, and I suspect the same type of questions will be asked if you decide to keep that invention as a trade secret. Obviously, the first obvious question is this invention going to be made public? So if it's going to become an obvious feature in a product or service and it is visible to Joe public, then it can't be a trade secret. So is it going to become public at some point in the future? That sort of kills the option of keeping it a secret. The second option is, remember, trade secret laws aren't like patent laws. Trade secret laws only protect against theft. They don't protect against reverse engineering, and they don't protect against independent creation. So a second question you should ask yourself is it relatively easy for this invention to be reverse engineered? If it's relatively easy, well, then trade secrets will not protect you, because trade secrets do not protect against reverse engineering. But then, where is this invention going to reside? If it's going to reside hidden away in the cloud somewhere, or deep in the bowels of your production facility, which is only accessible by your own employees, then you got to say, well, if I go down the patent route, this is going to be published, because 18 months after I file my patent, it will be published. So you've got to look at the invention and then ask yourself a series of questions. The secrecy aspect, can I protect it? Understand what it's actually protecting. It's protecting me against theft. So what are my risks? Is there a possibility an employee could steal it? Is there a possibility a supplier or a collaboration partner could steal it? Is there a possibility a competitor could steal it? So what's the risk when it comes to theft? Ask yourself about reverse engineering. How likely is it to be independently created? There is one place, since you asked the question about patents though, remember there is one place in patent law that trade secrets are mentioned. And that is when it comes to prior user rights. But hopefully, Jacinta, I've answered your question. Happy to follow up later with you if you want more details. But
Sure.
Very interesting question.
Yeah, but connected to the same question, I have one more. Like since you talked about independent creation, so if anyone independently comes up with the same, you know, with maybe it may be a coincidence, or it may be like a breach of, you know, someone might have passed on that information. So how easy it gets to prove that it was created independently and not by, you know, some source who might have leaked it from the original company.
Well, first of all, if there's a dispute, so if I accuse you of stealing my trade secret and we go to court, most court cases are what I would call a four-step process.
Okay.
First of all, at the beginning of the court case, the court has got to satisfy itself that we all know what the actual information we're talking about. So there's clear understanding of what the trade secret is that we're in dispute about. Secondly, I've got to prove that the information was a trade secret at the time of the alleged incident. Not today in the court, but at the time of the alleged incident. I've got to be able to prove this information qualifies as a trade secret.
Okay.
Next, I've got to prove that you stole it. And last but not least, I've got to prove that there was damage to you, there was damage to my company as a result of your theft of my trade secret. So I've got to get through those four hurdles. I've got to be clear as to what the information is with reasonable particularity. I've got to prove it was a trade secret. I've got to prove there was theft, and I've got to prove that there was damage. All you as the defendant have to do is prove that one of those is not true.
Okay.
That it wasn't a trade secret, there was no theft, or there was no damage. So that's in the event of a dispute. Now, you also asked about the independent creation. So let's say you independently came up with the same idea without stealing it from me.
Yes.
And then you decide to patent that idea. Now, I have the idea already, but I've kept it as a secret. And you later on independently came up with the same idea, but you patented it. Now, you would get the patent because my trade secret doesn't qualify as prior art, because the examiner doesn't even know, because I'm keeping it secret, he doesn't know anything about it.
Yes.
But in that case, I would have prior user rights because I came up with the trade secret and took it into use before you filed a patent. Now, if later on you discovered that I was using your patented invention as a trade secret, you could the advantage of saying our user rights. I was using the trade secret before you filed your patent. But the onus would be on me to prove it.
Okay.
I would have to prove that I had the trade secret in use before you filed your patent. Sorry for a long-winded answer there, Jacinta, but
No,
you
sure,
raised a number of interesting points about making the decision, what happens if there was a theft, and what happens if there was independent creation.
It's absolutely fine, Donal. But
yeah.
On the same subject, court cases, disputes and all, would you be able to throw some light on recent cases surrounding trade secrets and all?
Yes. Well, as I said earlier in the talk, trade secret litigation has been increasing. There's some very interesting data by a number of entities. Stout Research in the US publishes a report looking at US court cases, back both state level and federal level cases. Lex Machina have also produced a report. So there's plenty of data, and if anyone is interested, I can via Arindam get you, those reports are published, so we can share information afterwards. But if I highlight a few cases, And actually, there's an interesting case involving an Indian company, Tata Consulting. Again, a US case. Tata got accused of stealing a trade secret by, I believe the company was called Epic Healthcare. So Tata did some engineering work for a hospital in the US that was deploying Epic Healthcare's medical record system. And in order to deploy the system, Epic provided some documentation to the engineers from Tata. Later on, Epic accused Tata of stealing the information and not just using it for this particular project, but then taking it back into Tata and sharing it with others, including their own healthcare unit. So that case was quite a dramatic case. I'm not quite sure the exact year, 2017, 2018, I think. Tata were fined $970 million initially. On appeal, I think it was reduced to about 420 or 440 million. So quite a substantial fine for trade secret theft. The details of the case are available as well, because, but that's in essence what happened. It was a case involving engineering consultancy working for a client using a technology from a third party. Another case that's worth highlighting is the case involving, it's in the wind turbine sector, between AMSC, an American wind turbine company, and Sinovel, a Chinese wind turbine company. So this is a recent case in federal court in the US where the American company is accusing the Chinese company of stealing software that I believe is used to control the performance of the wind turbine under certain load or stress conditions. Now, the interesting thing about this case is it's a case in the US federal court, but the actual theft took place in Europe, in Austria, back in 2011. So what happened was a Serbian engineer working for this Austrian company left the company and was accused of walking out the door with some software on a memory stick. And then 5 or 6 years later, there's a court case in the US. Now you might say, what's the link between a theft in Austria in Central Europe and a US court case? The problem is that in the US, sometimes the US thinks very strongly about its borders. Other times it doesn't worry so much about the border. And the US federal trade secret laws basically are extraterritorial in nature. The theft doesn't actually have to happen in the US. There just has to be a link to the US. And the link in this case was the Austrian company, their parent company was a US company called AMSC. And unfortunately, when the engineer left, he joined the Chinese company, hence the link to the Chinese company. So some of these trade secret cases are quite complex because it starts in one part of the world involving one company. And then before you know it, it's another company involved in court because of these legal links between organizations or complex group structures or whatever. Another case worth studying, if you're interested in studying cases, is the case between T-Mobile and Huawei in the US involving the theft of a robot that automated the testing of mobile phones or smartphones within T-Mobile's test laboratories. And again, it's a really interesting case because back to the question that Jacinta raised, T-Mobile protected their robot using a combination of both patents and trade secrets. So some of the technology they decided to patent, and some of the technology they decided to keep secret. And I think it's a quite interesting case because more and more I see companies taking this dual approach to protecting an invention. There are lots of advantages of almost splitting the invention into two parts and patent protecting some parts of it and keeping other parts of it secret. And in this case, they patent protected the hardware and the mechanics, but the software they kept as a trade secret. Because when they analyzed their risks, they realized that there were risks internally, there were risks from collaboration partners, but also there were risks from competitors. They didn't want the robot to be mass produced by other test equipment vendors. They wanted to keep it unique. So in certain cases, patent worked well, but in other cases, trade secrets worked well. And I think it's a really interesting case for those interested in studying how invention handling works within large companies. But they would be the cases I would highlight. The Tata case, because it's a case involving a collaboration partner. The wind turbine case, because it's just so complex, and it's also it moves from one jurisdiction to another. And also the other interesting there was how long time it took to go to court. You know, from 2011 was when the incident happened, I believe, and the court case was 2019. So obviously, it indicates you've got to keep good records of your trade secrets, because in the court case in 2019, you've got to prove that the information was a trade secret, not in 2019, but back in 2011 when the alleged incident took place. It's no good going to court and say, trust me, Your Honor, of course it's a trade secret today. You need to prove to the court it was a trade secret back when the incident happened. And this is another issue why things like trade secret systems are growing in importance, because you need some sort of system to keep the records. I can barely remember what I did last weekend. I'm not going to remember what I did in 2011.
Yeah.
Sorry, a long-winded answer there, but hopefully it gave you some ideas of the cases.
We, I think, had someone raised a hand. Yes, Pranjal, you can have your question.
Yes, sir. Can you hear me?
Yes.
Yes.
So my question is regarding this artificial intelligence, as its role has been increased. So what if some invention, some artificial intelligence is involved in that invention? So in that case, what are the steps would be taken to protect that invention, and will there be any human involvement or that? So my question is regarding AI.
Okay, well, clearly we are seeing more and more companies using trade secret protection for things like software code, algorithms, raw data, processing data. So obviously AI falls into that space. I appreciate there's a long debate, heated debate about the patenting of computer inventions. That doesn't exist in the world of trade secrets. There's no requirement in trade secret law that the invention is developed by a human. I mean, if you have, for example, in very simple terms, let's say you had a very simple sensor taking readings. So it is a mechanical sensor, electronic sensor, and it is completely, there's no human involvement. It's just continuously taking some measurements. And you're taking those measurements and putting them into some server. So you're building up a large pile of data. That data can be a trade secret. Nowhere in trade secret law is there a discussion about whether the data was created by a human or a machine. That doesn't exist. So in the world of artificial intelligence, yes, there's nothing stopping you taking certain aspects of that artificial intelligence and treating it as a trade secret. So long as it is secret, it has value, and you take reasonable steps to protect it. Obviously, as discussed earlier, that trade secret protection does not prevent independent creation. It does not stop reverse engineering. So you've got to think, is that likely to be an issue for us in whatever you're working on? But if I understood the question about this this human involvement, that is not an issue at all in the world of trade secrets. It's a big issue in patents, obviously, because there's lots of heated debate as to whether you could have a computer as an inventor in patents. That doesn't exist in the world of trade secrets. Pranjal, did that answer your question?
Yes, I did understand it. Thanks for.
Any other question we have from anyone in this?
Hello, I have a question.
Yes.
Hello.
Yeah, good evening, sir. Sir, my question is related to, generally I see that most of the food invention, food related, like recipes or the secret ingredients or secret formulas, they are kept as a trade secrets. So, but nowadays, I mean, it's in today's world, it is very difficult to steal those kind of inventions. So, I mean, considering the today's scenario, do you advise these kind of, I mean, the practice of keeping these secret ingredients? Do you still, I mean, do you still suggest that the practice should continue like that? Or, I mean, in today's world, considering because of the theft and hackers are there around, so can we go for some different kind of protection considering the today's technology trends?
Well, I'm convinced that the trend is more towards trade secrets and away from patents. Even WIPO have said that. So I work with a lot of companies in biotech, in pharma, in food and beverage, and I don't see any slowdown in those companies keeping certain things trade secrets. I think that some of these companies are questioning patents because of the issues I talked earlier about patent reform, also the expense involved with patents, and also the difficulty in enforcing certain patents and so forth. So I don't see the trend away from trade secrets. I see the opposite. I see more and more companies beginning to think about trade secrets in parallel to patents. They're still patenting and they're still looking at other forms, but we see more and more companies beginning to understand that, well, actually, yes, I can also use trade secrets now, particularly in food and beverage, biotech. Remember as well, though, many of their trade secrets aren't technical. So these are trade secrets that could never be patented anyway, because they would never pass the patent criteria. So you have things like just large data sets and so forth.
So even for pharma companies, you would suggest that the non-technical know-how should be kept as the trade secrets?
Obviously, if it's possible, but remember, trade secret laws does not allow you to sort of bypass other laws. So for example, if you have health and safety or food safety regulations, or in the pharma world, you have to divulge certain things to the authorities and so forth. So this does not prevent you, or does not allow you to ignore any obligations you may have to disclose information. So trade secret laws, for example, do not allow you to say to pharmaceutical regulators that, well, I don't want to divulge this information because it's a trade secret. If you have to divulge it in order to get the approvals or whatever, you have to divulge it. So you have to be careful as to where and how you use your trade secrets, and what type of information can really work as a trade secret. But clearly, if it's non-technical in nature, then patents don't even come into the equation. And then you've got to look at, well, is it worth keeping as a trade secret? Will it end up being published anyway? But if it is technical, I think you need to really explore the pros and cons of patenting it, keeping it secret, or even publishing it, because publishing is also an IP strategy. But we're not seeing any slowdown. We're seeing the opposite. We're seeing chemical companies, pharma, food companies take trade secrets even more seriously. And this has been backed up. There's been studies in Europe, for example. There was an interesting study by the EU IP Observatory in 2017 that looked across a variety of industry sectors. And the results showed that almost all companies in all sectors were taking trade secrets extremely seriously. Now, whether they were actually doing it in practice is another question. They might say they were taking it seriously, but were they doing it was another question. There was an interesting report by Baker McKenzie, a global study that also looked at larger companies. And again, the feedback there was that they were taking trade secrets seriously. Did that answer your question?
Yes, sir. Thank you very much, sir.
Thank you.
Any further questions we have from?
I had a question.
Yes, Anuradha.
Yes.
So when there's a patent litigation, usually it starts with the process of discovery. So are trade secrets discoverable? Means are there, do you need to, you know, disclose your trade secrets when there is an extensive discovery?
Well, in the discovery process, there's ways to explain to the other party or to the court what is relevant and so forth and what can be excluded. So it could be an argument to say that there's certain information, but obviously that's really dictated by the judge as to whether he feel you have to disclose it or not. So you cannot just unilaterally turn around and say, well, this is a trade secret, we can't disclose it. I think you'd have to come up with arguments as to why that would cause damage to your company, whatever. But at face value, no, the argument of just saying it's a trade secret, so therefore I'm not going to disclose it. If the court was to insist on it, then you might have to come up with arguments as to why not. But as such, just saying that it is a trade secret and therefore I'm excused from disclosing it is probably not good enough. But I'm not the legal expert there. I can follow up with you separately and explore that. But as far as I'm aware, no, it would be answered. It wouldn't be as simple a case of saying that's a trade secret, I don't have to disclose it. You would have to come up with stronger arguments, I would suggest.
Okay, thank you, sir.
And any more questions from anybody?
Of course, back to the question. Of course, it could be that you could disclose it, but explain that it's a trade secret. So therefore, you want the secrecy maintained somehow. You want protection mechanisms put in place so it isn't in any way published and is only limited to a core group who need to have access. So there are mechanisms, particularly in the US and other places as well now, to maintain the secrecy of a trade secret that gets dragged into a dispute.
Will it be under the same bracket as attorney-client privilege or confidential information? Will it be put in the same bracket?
Not sure. I obviously, if your trade secret has never been disclosed to your attorney, then it probably isn't under attorney-client privilege. So I doubt it's under the same bracket, but I know at least in these trade secret disputes, one of the key developments in the law has been this ability to keep the secret during and after the court case. But your question is slightly different. You're talking about a patent dispute in the discovery process. So I would need to check and get back to you on that one. So maybe we can connect separately and I'll explore that issue.
Yes, thank you.
I have one question, sir.
Yes.
Yeah, so basically connected to the same point that you mentioned. So for example, there someone takes a company to court, and there the company is supposed to disclose what is a trade secret. Then in that case, if it was actually a trade secret, so and it's revealed to all the parties around, so what are the measures that can one take to still protect it? I mean, is there any
Yes, in the new laws, they've deliberately put mechanisms in place.
Okay.
Because the reason why there were so few trade secrets before was that if I was the plaintiff and I accused you of stealing my trade secret, I would have to divulge in court and to everybody what the trade secret was. So it was pointless me going to court because I'm thinking, well, everybody's going to know the trade secret now. One of the main changes in these laws I talked about earlier is the fact that there's now a mechanism within the court to keep it secret so that not everybody knows about the secret. It's only on a need-to-know basis and isn't published in the court records afterwards. Now, the details of that mechanism, I think, varies by court, but there are these mechanisms in place now, so your trade secret is not divulged. It's obviously divulged to a small group of people in the dispute, but isn't widely divulged, and it keeps its secrecy. So the information stays as a trade secret, even though it's been involved in a court case.
Okay. Okay. And do people use, I mean, do companies I mean, this is a very, on a different aspect altogether. They use trade secret as a, as a shield against infringing activity, not against, I mean, to do some infringing activity. Like, for example, if they are already infringing over some patents, but they try to protect that and say that it's a trade secret. And so other companies who would want to know which companies are infringing, they will never come to know, because it is protected as a trade secret. So such incidences, do they happen?
I'm not sure if I understand it, but just to clarify one point. Trade secret law cannot be used to protect any illegal behavior.
Yeah.
So if you're doing something illegal, you can't. If I'm doing something illegal, so there are exceptions in trade secret laws, and one of the exceptions is wrongdoing. You can't, or so there are a number of exceptions. Particularly if you look at the European directive, it's outlined very clearly what are the exceptions. So I cannot use trade secret laws to say, well, I'm not going to. If I understand your question right.
Yeah. So what I'm trying to ask, what if it is shielded? How would one even come to know that it is, being used by the companies because they protect it? They don't publish it anywhere.
You never know. You'd never know.
Yeah.
Yep. You'd never know. So if you would just never know.
Okay.
Yeah. By the way, one other point back to one of the earlier questions about this trend. One thing to sort of confirm why I believe trade secrets are growing in importance. Two other pieces of information. One is that for the first time, we're seeing insurance providers beginning to offer trade secret insurance.
Okay.
So companies like Aon, IPISC, Marsh, Gallagher, some of the big insurance guys, as well as the boutiques. So that's an interesting development. So the very fact that the insurance industry is beginning to pay attention to trade secrets is an indication that this is becoming more serious. The second indication is that you are beginning to have entities that fund litigation now fund trade secret cases. Previously, a lot of the IP funders or litigation funders would focus on patent disputes. But you now have, particularly in the US, but not only in the US, you have entities that will fund trade secret disputes. Okay. And that's another indication that they're also noticing this trend. In other words, just look where the money is going. They always say follow the money. Well, if you look at the money by the insurance guys and the litigation funders, some of it is moving towards trade secrets. And that's also an indication that things are happening in this space.
Sure. Thank you, sir. Thank you so much for answering that.
So we are almost close to the hour. Donal, I may just have any last questions from anybody participating here.
Hi, I would like to. Oh.
Yes, Aradhana.
Hi, I would like to find out, is law of confidence a written law? I actually don't see it anywhere, just like we see patents law, trademarks law, copyright law, but I don't see a law of confidence. Am I mistaken? Please guide me on this. Thank you.
So the laws are these are laws, trade secret laws. So often you don't look at under IP to find them. They're elsewhere in the legal space. But so the US law I mentioned is a law called the Defend Trade Secrets Act, passed by federal level in May 2016. The European law is a law called the European Directive on Trade Secrets from June 2016. The Chinese law is a law called the Anti-Unfair Competition Law. I think January 2018 was one change, and then it was updated again in April 2019. The Japanese law is from January 2016. I'm sorry, I've just gone blank. I can't remember the name of the law. So we will send, with Arindam, we will send out a paper in the next few days with some more details about some of the issues I talked about, and maybe links in that paper. So I will discuss with Arindam afterwards, but we'll get a paper out to you. But if it's urgent, please, by the way, I regularly post stuff on LinkedIn as well and so forth. So feel free to connect to me. But we can get you details of these laws if that's an issue.
Thank you so much. Thank you. Much appreciated.
By the way, I do not believe that there is strong trade secret law in India. I should clarify that. There are laws to do with confidential information and so forth, but I don't believe that there is a specific trade secret law in India. Now, as countries engage more and more in trade agreements, particularly if any country gets involved in a trade agreement with the US, you will be under pressure to implement a local trade secret law. It's interesting. If you read So obviously China and the US have been involved in a dispute for a long time. In January of 2020, they signed phase 1 of the trade agreement, which was meant to bring an end to these tariffs and disputes. It's a 92-page document signed on the 15th of January 2020 between the US government and the Chinese government. The very first section in the agreement, it's not about tariffs. It's not about Chinese buying more soybeans from American farmers. It's not about disputes in the South China Sea. The very first section in the trade agreement is about trade secrets. The very first thing they talk about is about trade secrets in the Chinese-US trade agreement.
Yes, that's right. Yeah.
So,
hello.
Hello.
Yes, sir. I have one. You are just. I am doing LLM. My dissertation topic was trade secret legislations in India. Okay. So you have taken a, you have taken this topic. You can able to give justification. See, we are not having any unique that separate legislation for trade secret. As you said, exactly correct. And we are following the TRIPS agreement also. As per TRIPS agreement, trade secrets are part of intellectual property rights.
Yes.
But India doing with just litigations are taken care for with the contract law, and this is they've been giving any infringement of trade secrets have been taken covered by agreement that contract act only. So I want to ask you, some outsiders, do you what do you think that a country should have a separate legislation for trade secret? What is the mandatory for it? Though they have that colonial legislation, something for contract act, they have been doing it. What do you mean by they're doing this successfully? They're saying it. In spite of that, why we should have separate legislation? If you tell it, really helpful for my career and my academic also, please.
Yeah. Well, I mean, no country is an island these days. Every country interacts. Businesses in countries interact with businesses in other countries. People move around and so forth. So it is, as you see other countries enact strong trade secret laws. And remember, IP laws are enacted by countries to promote innovation and creativity within the country. I mean, if you look back at the history of IP, why are they there? They're there to promote innovation and creativity. And there's evidence that says that strong IP laws in a jurisdiction give that country some sort of competitive advantage over countries that do not have strong IP laws. Now, with the rest of the world enacting stronger trade secret laws, that's one argument why I think that there's a strong argument for India to at least look in the mirror and say, is now a good time to enact good trade secret laws? Secondly, India is also very interested in its own innovation and creativity. Now, admittedly, some of the innovation and creativity going on in India probably can be protected by patents, design rights, and so forth. But clearly, some of those IP, other forms of IP, have their weaknesses. And why shouldn't Indian companies be able to avail of strong trade secret laws in those areas where trade secrets make sense? So if you're going to support businesses, then absolutely. Thirdly, what happens in the situation where an India company is engaged with some collaboration with a US company or a Chinese company or a European company? Does it weaken the position of the Indian company if the person across the table is supported by stronger trade secret laws in their jurisdiction? So I am a supporter of, I'm clearly a supporter of IP. I clearly believe that trade secrets has a place to play. I admit it doesn't work all the time. It has its weaknesses, but so does patents and so does trademarks and so does designs. All forms of IP have their oddities and idiosyncrasies. But I'm very happy to continue. I don't mean to take up so much of this webinar, but I'm really interested in what thesis research you're doing. Very happy to connect with you. And again, through Arindam, we can talk offline. But I suspect that you're not probably the only person looking at this in India. That now, in terms of places to look at, by the way, even though they probably don't enforce it the best, I think one of the best countries that done the best in terms of creating a trade secret law is Russia. Their trade secret law, I think, is very well crafted.
Oh.
But happy to continue this discussion separately. But
Yes, sir, please. I think you share your email ID and pass email ID, right? I'll just have an offline discussion with you. It's more interesting that you're taking it very clearly because I want to do research on it. Everybody is questioning me why you're taking some. This is a very clutch area. It is not very mandatory for a country to be there. Apart from other IP, it's very weak IP. Something right. But my concern is I want to prove it that other countries are very strong in trade secrets. They have separate law for it. As you said, especially Russia. Why we should not have it? That is my concern.
Yeah, let me give you one example. I appreciate that the pharma and biotech industry is very strong in India. It's one of your, okay. I conducted a workshop on trade secrets for one of the big 5 pharma companies in Europe a few months ago. So typically one associates patents with big pharma. But this big pharma company had decided that they also wanted to take trade secrets deadly seriously. And I was engaged to conduct a one-day workshop, a master class on trade secrets. Now, I was extremely surprised to be asked to do this because I assumed, I said, why would you be interested in trade secrets? And they said, we know about patents and we're very good at patents, but we also want to get very good at trade secrets. So I think that there's lots of arguments why this needs to be investigated. And the good thing is you've got lots of data to look at because you can look at what other countries have done, what worked well, what didn't work so well, and so forth. So, but yes, sorry to go on about that answer so long. I apologize.
Yes, sir. Yes, sir. Thank you. Thank you. Thank you.
So, any last question we can take? Otherwise, I think we are well past the time. We can perhaps wind up our session here.
If you have any questions that perhaps you may not feel comfortable asking them personally, feel free to drop an email to Arindam. If there's something you think about later or something you should have asked and you didn't ask, please feel to get back to Arindam and we can discuss and maybe help you.
We'll connect.
Sir, please share your email ID, sir, please.
Okay.
Okay, all right. Thank you, Donal, for taking the time out and sharing your knowledge and wisdom about trade secrets with us. It was a pleasure having you here.
Thank you for inviting me. It's been an honor, and I greatly appreciate the opportunity.
Yes, I thank all the participants here, and with this, I think we can close the session for today.
Perfect.
Thank you, Donal.
Thank you. Stay safe. Bye for now.
Same to you.